Good morning, everyone. We'll just give it another 10 seconds or so, and then we'll kick off this afternoon session. Good afternoon, everybody. For those who don't know, my name is Stephen Kelly. I'm the Chief Executive of Manufacturing Northern Ireland. You're all very welcome along to this afternoon's webinar. I'm very pleased to welcome both Robert Connor, who's a solicitor, and particularly Glenn Watterson, who's a partner with Mills Selig, who are a corporate law firm based in Belfast and who partner with Manufacturing NI on legal issues. And we're particularly pleased to welcome them along today to run through a session with us on directors' roles and responsibilities. We've had significant interest in this event, and we're very pleased that you're joining us live, or those that are watching later on in the recording. We will be sharing the recording of the event, and we will also be sharing the slides that Glenn has offered up to us today after the event. So do keep an eye on your inbox over the next day or so, and we'll make sure that those are passed out to you. We're obviously living in an incredibly tricky time. It's never been probably more difficult to be in business. There's lots of changes in terms of responsibilities for directors. So today is a really good opportunity to hear directly from the experts on that issue, and to ensure that you as a director or people that you're planning to bring through as directors in your business are operating your business in a safe and legal way. And that's where a firm like Mills Selig are particularly helpful. Glenn will take us through his slides, but do take the opportunity to ask any questions in the Q&A function. If we have a chance to answer those directly during the session, then we will do. Or if you wish, put the questions in the chat function as well. I'll be coming back later on after Glenn has done the presentation, and we'll put some of those questions that you've raised directly to Glenn. Obviously, this isn't about offering legal advice or free legal advice, but it's about giving you the broad picture of what it means to be a director in a business and to ensure good corporate governance and compliance within your business, to protect you as an individual, protect the people who rely on you in terms of employment, and to protect the business overall. So you're all very welcome. Please do engage by asking questions. We'll not be offering free legal advice, but obviously, of course, recommend that you pick up the phone and ring Glenn and his colleagues. But do take the opportunity to ask those burning questions that you may have, and we'll try to get round to those at the end of the session. Glenn, you're very welcome. I'll hand over to yourself, and we'll see you later on in the session.
Super, thank you very much, Stephen. You can hear me okay? Just checking, Stephen, everything's okay?
Yeah, we can indeed, yeah. We can indeed.
Perfect. Morning, everyone. Look, thanks for our afternoon now. Thanks for being with us. As Stephen said, I'm Glenn Watterson, a partner in the corporate department at Mills Selig, a corporate law firm in Belfast. I'll give you sort of just a quick overview, a quick plug of Mills Selig and what we do. We're a sort of locally owned, wholly independent law firm, specialising in all aspects of business law, and what we really strive to become is kind of like the legal wing of our clients' businesses, really getting to know the clients and getting into the sort of nooks and crannies of the business. And I think directors' duties and corporate governance is certainly one place where, you know, we can really sort of partner up with the clients. In terms of today's webinar, I want to firstly touch on a quick overview of corporate governance and why that's important. Strong corporate governance assists directors in fulfilling their duties, as it provides a foundation for decision making. Corporate governance is the combination of rules and processes or laws by which businesses are operated or controlled. The term encompasses the internal and external factors that affect the company's stakeholders' interests. So that'll include shareholders, customers, suppliers, regulators, and the business's management as well. It covers decision making and the layers that form that decision making process. Good corporate governance will ensure that the board of directors meet regularly, retain control over the business, and are clear in the division of their responsibilities, as well as maintaining a system of risk management. Basically, it's the way in which a company, its directors and senior management make decisions and carry out the executive function. So why is good corporate governance important? Strong and effective corporate governance helps to cultivate a company culture of integrity, leading to positive performance and sustainable business overall. Essentially, it exists to increase the accountability of all individuals and teams within your company, working to avoid mistakes before they can even occur. When your business has strong corporate governance, it'll signal to your customers, competitors that your organization is well managed and that the interests of management are aligned with all of its external stakeholders. As a result, it can provide your company with a strong competitive advantage. Essentially, what you're looking to do is eliminate as much risk as possible. The importance of corporate governance is made apparent by positive impacts that occur when risks are controlled, and your procedures are streamlined and consistent. So we just look at a few reasons why strong corporate governance. Next slide. Sorry, Robert. Sorry, previous slide. So if we look at a few reasons why strong corporate governance is important, it makes your processes more efficient. So due to repeatability and consistency of the tasks that the business is performing, errors will become more visible. This repeatability and consistency helps to quickly identify the non-conformities in any processes. Your costs will be reduced, tasks are streamlined, companies can eliminate the waste from scrap work, from reworking processes and any other costly inefficiencies. And that results in your operations running smoother. Regular disruptions from inconsistencies are eliminated. Now, I don't want to step on the toes of any budding corporate lawyers out there, but before we go into your roles as directors and the duties that you owe to the company and its stakeholders, I want to just sort of firstly touch on the structure of a company. Essentially, a company acts through two bodies of people. That's its shareholders and its board of directors. The shareholders of a company, firstly, are effectively the company's financial supporters. They provide finance to the company by purchasing shares and thus become shareholders and part owners of the company. Under company's legislation, certain decisions and actions can only be made with those shareholders' consent, such as changing the articles of association of a company. That's its constitutional document. Removing a director from office rather than that officer simply resigning, changing the name of a company, and entering into director service agreements for a term of more than 2 years. However, generally in the absence of a good shareholders agreement, which I'll touch on later, shareholders have very little power over how the directors and how they run the company. Their key role is to attend meetings, discuss what's on the agenda, and ensure directors do not go beyond their powers and provide any consent that shareholders need onto the articles. Then the board of directors, secondly, they oversee the management of the company's business, and they make the strategies and operational decisions of the company and are responsible for ensuring that the company meets its statutory obligations. The directors are effectively the agents of the company. They're appointed by shareholders to manage its day-to-day affairs. So the responsibilities of the directors and directors' duties, as they're commonly known, under the Companies Act 2006, which is your main company's legislation in the UK, there are 7 statutory duties. The first one there is the directors must act within their powers. They must act in accordance with the company's constitution and only exercise their powers for the purpose for which they're given. The constitution, as I touched on before, includes the articles of association, resolutions and agreements of a constitutional nature, so shareholder or joint venture agreement. It's a key consideration for yourselves as directors to familiarise yourself with the company's articles and shareholders agreement, as they'll set out any limits there are on a director's powers. Secondly, now what is probably the most important consideration or duty for you as directors is that you must act in a way that you consider in good faith would be most likely to promote the success of the company for the benefit of the members and shareholders as a whole. Success will generally mean a long-term increase in value, but fundamentally, it's up to each director to decide in good faith whether it is appropriate for the company to take a particular course of action. When considering what is likely to promote the success of the company, the legislation provides that a director must pay attention to the likely consequences of any decision in the long term. The employees of the company sort of need to foster its business relationships, the impact of company's operations on the community and the environment. Now that's a particularly recent introduction, and obviously moving with how the world is at the minute. The desirability of the company maintaining reputation, high standards of business conduct, and the need to act fairly between the shareholders of the company. That's not an exhaustive list, but it's really to highlight the areas that are of particular importance to you, and there are other factors obviously that should be considered as well from business to business. I appreciate that may seem slightly intimidating, but the key thing to consider here is simply the success of the company. Issues won't arise out of every single decision you make, but it's important to keep these in mind at all times. The next one, to exercise independent judgment. It's pretty straightforward. You must make your own decisions. It does not prevent you from acting in accordance with the Constitution or shareholders agreement. So if there are sort of restrictions or parameters placed within those, then you obviously have to comply with those as well. Fourth one is exercising reasonable care, skill, and diligence. So directors must exercise the same care, skill, and diligence that would be exercised by a reasonably diligent person with a general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same functions as them in relation to the company. So that's an objective standard. And then there's also a subjective standard, which is the director will be considered to have the general knowledge, skill, and experience that director actually possesses. So, for instance, if you're a lawyer or accountant, you'll be judged by those qualifications. The fifth one is to avoid conflicts of interest. And this is something we would get asked about quite a lot, but the directors must avoid a situation in which they have or could have an interest that conflicts with the interests of the company. It applies particularly to the exploitation of property, business information, and other opportunities, regardless of whether or not the company could take advantage of it. So if you think you have a potential conflict of interest, the first thing you should do is raise it at board meetings, seek approval for the board if they have the power to authorize the conflict, or the shareholders if they don't. And secondly is to check the articles of association, as they may, but they most likely will, have provisions that relate to conflicts of interest. The sixth one is the directors must not accept a benefit from a third party, where that benefit is given because a person is a director or as a thank you for anything they do or don't do. Obviously, there's varying degrees of benefits, and this duty is closely tied to the conflicts of interest. But you'll be glad to hear that the case law recently has determined that corporate hospitality, for instance, is not prohibited, and directors can receive benefits as long as accepting that wouldn't reasonably be regarded as giving rise to conflict of interest. So any bottles of whiskey or champagne you might have received at Christmas won't need to go back just yet. And then finally, again, tied to interest, is to declare interest in proposed transactions or existing transactions of the company. So if you've any interest, whether directly or indirectly, in a transaction or arrangement with the company, you must declare that and the extent of that interest to the other directors. You must do it before any transactions entered into, if it's a proposed transaction of the company, and if it's an existing transaction where the interest arise, you just must do it as soon as possible. Take note, though, that duty will not be infringed if the interest you have in a transaction cannot reasonably be regarded as giving rise to conflict, or the interest you have has been declared as soon as you've obviously become aware of it and been accepted and passed by the shareholders or the board, as the case may be, in your articles of association. When we prepare board minutes and things for companies, a properly convened board meeting will always sort of start with the chairman setting out the businesses to be discussed, and then that gives directors an opportunity to declare any interest they have. So it's just something to keep in mind when you're holding your board meetings. So in addition to your 7 statutory duties, there are some others that sit sort of outside the Companies Act as a legislation. Examples would be the duty of confidentiality. So obviously you can't go and pass off company information to other people where that wouldn't be in the company's interest. A little bit of a crossover with promoting the success of the company there. There are duties to employees, so you're responsible for ensuring that the company complies with its obligations relating to health and safety and the welfare of your workers. And finally, there's some obligations that are beginning to creep into legislation now under environmental legislation, anti-corruption, and that sort of stuff. We'll touch on that at the end of the webinar. So what are the sort of key issues that arise and the areas of risk? I've put on the slide here a couple of examples where sort of poor corporate governance has led to particularly serious situations for a couple of famous companies. Corporate governance directly impacts the profits and reputation of the company, and having poor policies can expose the company to lawsuits or fines, or most importantly, reputational damage in these 2 instances. The first one's P&O. You'll likely remember that P&O made a vast number of redundancies and replaced their staff with cheaper, more flexible agency staff. And there was a citation in the judgment there that the directors knowingly broke the employment laws, and obviously the knock-on reputational effect for P&O was disastrous at that stage. And then Carillion, again, an industry you'll probably be aware of. You'll recall that the sort of demise of Carillion, they embarked on a particularly aggressive expansion, which ultimately couldn't be financed and ended in insolvency. And we have a quote there from the judge in that case that said that where there were director disqualifications and non-executive directors weren't even banned from acting as directors. So it's just clear to see, like, if you sit on a board of directors, it doesn't really matter what your role is. If you're in a particular area of the business, if you're HR or your sales, but there's issues with the finance section, then you're all sort of captured under the same umbrella. So the common sources of risk, first of all, conflicts of interest. I don't know, I've talked about it at reasonable length there, just on the duties, but when a conflict of interest occurs, an example may be a board member who owns significant shareholding in an entity that competes with or has a trading relationship with a company that they're a director of. That's a conflict of interest. So when conflicts are present, they deteriorate the trust of shareholders and other stakeholders, making the company sort of vulnerable to litigation. Oversight issues. So directors need to have substantial oversight of the company's procedures and practices. The board of directors need to ensure that where any level of management below them has the ability to make decisions or commit the company, that they have a strong enough control over that function. Now, oversight's a broad term that encompasses the executive staff reporting to the board and the board's awareness of the daily operations of the company and the way in which its objectives are being achieved. The board needs to protect the interest of shareholders in the ordinary course of business, so acting as a check and balance. Without this oversight, staff might violate laws, cut corners, and can make the company vulnerable to claims, fines, and other reputational damage. Accountability issues. So similarly, in terms of the decision-making function, each level and division of the company should report and be accountable to another, culminating at the board level as a system of checks and balances. So above all else, the actions of each level of the company are accountable to the shareholders and other stakeholders. Without accountability, one division of the company might endanger the success of the entire company or cause shareholders to lose desire to continue their investment. And then accounts violations. So this really, we're getting in a little bit to insolvency law, but this is a key area, and I'm sure one you'll be interested to hear about. Where there may be exposure for you. Where a company is in financial difficulties, directors should seek independent advice as soon as possible if they're going to avoid potential personal liability under insolvency legislation. The risks for a director in this area are complex and include disqualification. So the insolvency service and the courts can give disqualification orders of up to 12 years for a person who's a director and found guilty of offences. This is where your duty to exercise due skill and diligence comes into effect. This is where it's very easy to demonstrate when a company is prosperous and financially sound. However, if a difficult decision needs to be made to secure a company's financial standing, those decisions obviously become a lot more difficult. And some of the key issues then that you'll need to be aware of are where a company's facing insolvency, that the general duty of care to act in the best interest of the company's shareholders, that changes and sort of pivots to the company's creditors, because at that stage it's the creditors who are exposed when the finances are on a downward spiral. Wrongful trading, we've touched on there, is a director could be ordered by the court to contribute towards the general pool of assets that are available to companies' creditors, in the event of insolvency. That's where he or she knew or ought to have known that there was no reasonable prospect of the company avoiding insolvent liquidation or administration. They continued to allow the company to trade after they knew or ought to have so concluded that insolvency was inevitable, and they don't take every step that they ought to minimize the potential loss to creditors. So it's just important to realize that pivot from success, acting in the best interest of shareholders, to act in the best interest of creditors where finances are going down. You don't need to have been dishonest to be liable for wrongful trading, and you can't avoid responsibility by simply resigning when potential difficulties are spotted. It's a particularly thorny area, the insolvency legislation and wrongful and fraudulent trading, and proper advice should always be sought. Touch a little bit on shadow directors and de facto directors, if that's relevant to any people on the webinar in particular, or perhaps other people who are around the board, around the management function in your company. As we discussed, people that are appointed as directors of the company have certain statutory duties to abide by, and they can be held liable for that conduct. What few of you may be aware of is that individuals who are not actually involved in the business, listed as directors, can in certain circumstances be found liable for breach of directors' duties without formally being appointed. So these individuals are known as shadow directors or de facto directors. Quite similar, the two terms and what they are, but a shadow director is a person or a corporate body which, although not officially appointed to the board of directors, controls or influences the management of the company by making decisions behind the scenes. De facto directors are those people who behave as and are understood to be directors in the first practice, whilst not being formally appointed. It's important for each of you, when you're in management roles or senior positions within a business, to minimize the risk of being considered a shadow or de facto director, or to avoid any potential liability for conduct which may not be in keeping with the duties and responsibilities imposed on directors. So that's where you're not actually appointed as a director. It's in particular concern where the company is experiencing financial difficulties, and the action of the board and other senior personnel will be subject to closer scrutiny. We would get asked a lot of questions, mainly in insolvent situations, by directors where they know that somebody who's not appointed to the board has been, placing control, sort of acting, making decisions in the background, and that's sort of led to financial difficulties. So move on to sort of some advice now. So steps to follow, and the first one is the Article of Association, which I'm sure you'll all be aware of and what we mentioned earlier. Under the Companies Act, all companies must have an Article of Association. The internal arrangements or rule book of the company, and they're filed at Companies House and publicly available. They deal with shares and membership, directors, board meetings, and any changes that are to be made to the articles. They can be bespoke, they can be model articles which are sort of prescribed by statute, and they can be a sort of a mix of the two. As directors, I would thoroughly advise that you familiarise yourself with the company's Article of Association, and if there's a shareholders agreement, and most particularly the provisions that deal with making decisions and conflicts of interest. Another key thing to be aware of, which is usually covered in articles, is record keeping and board minutes. One bit of advice is where you're having your board meetings, when everything's properly convened and quorate, and you've more than just a single director, it's taking a record of the decisions, the discussions, and how decisions are reached. Shareholders agreements, they're similar to articles in terms of they cover rules and how a company must govern itself, but it's a private contract and it's entered into between shareholders of a company and normally the company itself to govern the relationship between them. Our advice to clients is always, where you have two or more shareholders, is to have a shareholders agreement there. It's the first question we ask when there's been any sort of disputes or people are bringing claims against directors. It doesn't get filed at Companies House. And again, if you're a director of a business and whether or not you're a shareholder, it's important to familiarise yourself with the terms of the shareholders agreement, because it may include vetoes that a shareholder has over the actions of the board and any restrictions on the board's powers. It's pivotal in protecting the interests of the shareholders and enables them to have more input and control over the directors. Typically, what the shareholders agreement deals with is appointment of directors, decision making, consent mechanisms, restrictions on the transfer and issue of shares, any withdrawal from the company, and dividend policies. So the next piece of advice would be to take advice. It's not every company where the members of the board have the necessary training, skills, or experience to cover all areas which may lead to risk for a company. I would suggest that if you have a company or you have a power to appoint the directors, that you have a good range of professionally qualified board members to cover things like legal and financial or HR. But a lot of potential problems can be sort of headed off by taking the appropriate professional advice. So, legal advice, accountancy advice, having your insurance advisors, HR, and just sort of general risk management. The accounts violation that I mentioned earlier, so wrongful trading and insolvency and things, and the risk of fraudulent trading as well, is one area where risk can be limited by proper training of directors and executive level employees. Similarly, ensuring that the company provides regular training to senior employees reduces the risk of claims and loss. Directors and officer insurance, maybe one you won't be as familiar with, but we're seeing a particular rise in companies putting in place D&O insurance, particularly in exit scenarios when companies are being sold, and that they're recommended for non-executive directors in particular. D&O insurance policies offer liability cover for directors to protect themselves personally from any claims that may arise from decisions and actions taken within their regular duties. And then finally, service agreements. Properly drafted director service agreements are advisable in order to protect the company and the other directors against any directors who are in breach of their duties. In terms of recent changes to legislation and rules that you ought to be aware of as directors, the main one we have is the data protection legislation and how that falls back on the board. By way of background, and you'll be well aware of it now given the passage of time, but the European GDPR came in force in May 2018, and after the UK left the European Union, it was enshrined in the Data Protection Act. The legislation aims to give citizens and residents more control of their personal data. So everyone has a right to find out what information the government or businesses or organizations hold about them. It also simplifies regulations for all businesses to help them protect their personal data, and making sure that anything they use personal data for is either lawfully or fairly and transparently processed. You may think that this only applies to larger companies, but in fact, most businesses will hold personal data, be it individual customers or HR information about staff. The GDPR has introduced sort of rigorous security systems. There's requirements to appoint a data protection officer, have processing clauses in contracts and things. So certainly something that I'd advise companies to take advice around. It's important to ensure your company's compliant as well with the requirements set forth in that legislation. The fines have been increased a lot, and the maximum fines are the greater of 17.5 million or 4% of annual turnover. Obviously, that's the sort of biggest case breaches and things, but it's something, particularly if we're selling companies or buying companies at the minute for clients. It's one of the questions that's right at the start of the list, is what are the steps you're taking to be compliant with GDPR. Something for the modern world now, and where we are in recent years. Society's become increasingly concerned about corporate and social responsibility, and the need to be proactive on social matters such as race and gender equality, the environment, poverty, and mental well-being. Businesses have become focused on aligning their own interests with this, and have subsequently been ramping up policies and things that they're doing, whether it's champion women's rights, protecting the environment, obliterating poverty on local or national or global levels. Being a socially responsible company can bolster a company's image, build its brand. It empowers employees to leverage the resources they have to do good things. So having a formal CSR program can boost employee morale and lead to greater productivity in the workforce. Another recent change is the strategic report and non-financial disclosure regulations in 2022. Currently, these only apply to the largest of companies, including public interest entities, publicly traded companies of a certain size. But what they say is that in the annual reports of within the audited accounts, a business needs to set out the steps it's taken to protect the environment and lower its carbon footprint. Now, there are very few companies in Northern Ireland, Indigenous companies, that will be caught by those regulations, but slowly but surely, legislation in other parts of the European Union is starting to capture more and more companies. So we see that as a trend that will only develop and start to capture, at the start, the larger companies in Northern Ireland, but it's something that's coming into play for everybody. The next one is anti-money laundering. So, for those businesses that handle money that's not just sort of payments of invoices, it's been a big area for regulation and potential exposure for directors, particularly in business that I'm in recent years, with introduction of a raft of regulations and an increase in penalties. Tighter legislation surrounding anti-money laundering, it's been placing more stringent liabilities on companies and duties on directors, so it's something to be aware of. In March 2024, the Economic Crime and Corporate Transparency Act came into play as well. This act, it's a major overhaul of the UK government's framework for tackling financial crime, and it's brought in force a number of significant changes to how you file your documents at Companies House and what information you need to include when you're doing your annual returns, your confirmation statements, and those sort of things. In terms of potential future changes, we still see it going down that line of extending a director's duty to promote the success of a company, to have pay more attention to CSR, ESG, those sorts of things, and more to, I've put on the slide there, there's a draft Better Business Act, which is a white paper that's sort of been floating about for a while. And it's proposed to sort of change the focus of that section 172, which is promoting the success of the company, to that being more to advance the purpose of the company. So it captures more than just a sort of financial viewpoint. The Better Business Act campaign wants 4 principles to be reflected in that section 172, which is to ensure the interests of shareholders are advanced alongside the wider society and environment. It empowers directors to exercise their judgment in weighing up and advancing the interests of all stakeholders. The one that's default, so it applies to all companies, whereas, as I touched on with the the non-financial disclosure regulations, it's only the biggest of companies. And it's to require businesses to report on how much they balance people, planet, and profit really in their strategic report each year. That changed Section 172. It'll help bring company law into alignment with broadly recognised imperatives for business to work towards the UN Sustainable Development Goals and agenda, and for the UK and other jurisdictions to meet the decarbonising targets. I think that should be me, Stephen, for the formal part of the proceeds. So look, I'm happy to field any questions if anybody has them. I've seen a few comments coming into the question box there. And also look, happy to have a chat with anybody after this as well, if anybody's got any particular issues they want to run through.
No problem, Glenn. Much appreciated. Thanks very much for that presentation. It was really clear and precise set of guidance for everyone. I mean, there are a couple of questions that we've had, but I'm going to start with one of my own. You said at the beginning there about the kind of 7 statutory responsibilities for directors, and there was this phrase, the success of the company, and there seems to be a lot hanging. There's a lot of weight placed on the interpretation of the success of the company. Can you give us a couple of examples about what that might be, so that people kind of bring that into kind of real life decision making that they have within their business?
Yeah, look, I sort of spoke, Stephen, about there being a number of stakeholders. It'll depend from business to business, but typically the first stakeholder anybody thinks of is the shareholders and its economic value. Yes, most of the risks as a director are, am I going to be in trouble? Am I going to get disqualified, or taken to court, or asked to contribute to the assets of a company when it's wound up or becomes insolvent? But towards the end of the presentation, I touched on the more of the community, your employees, and things like that too. So there's been advances in employment law as well, where companies owe an even wider set of obligations to the employees. So I suppose you're always going back to the financial side of things. It's always going to be a director's first thought, but I think at the minute, in terms of legislation and exposure, that still has to be the first thought for directors. Is this decision I'm making going to guarantee success in a financial sense in the future? Rather than saying, well, I might sort of end some property here, but it might cost a lot of people money and the company's going to go bust, because that is where they're more likely to face punishment at this stage. So there is a general sort of swing towards the sort of community and the environment and the wider stakeholder group. But essentially, like, if I'm honest, it's still going back to bottom lines.
And you did cover that kind of that ESG piece. So in your summary just now, you talked about community. Expand that out into a wider kind of place. It's the environment. It's where people are procuring from. It's decarbonisation. It's a whole raft of legislation. But is this ESG thing, for want of a phrase, likely to put businesses out of business unless they, from a legal perspective?
Look, I think the ESG trend, it's clearly it in light of everything since, I suppose, particularly the last general election, there has been a little bit of a pivot. There's been a pivot in the States where all of a sudden the focus on that slowed down just because of market and economic turbulence. I would just be, for everybody on this webinar, I'd be keen to say it should be a consideration, but it is not your primary consideration, because the size of companies in Northern Ireland, I say very few are going to get caught by any actual legislation at the minute. In the Republic of Ireland, there are far more companies being captured by this, and it's the same throughout Europe, just with European legislation, that you need to do these reports, you need to say why and what you're doing. to help the environment and things. But I think at this stage, I wouldn't be saying stop what you're doing, stop worrying about your bottom line, and go out and do things that cost you money or jeopardize the future of the company to try and hit ESG as a sort of sign off. But that will vary from company to company because some companies are set up for that sort of purpose too, particularly community interest companies and that sort of thing.
And you introduced this concept, which was, even though I've been a director of a variety of organizations and I'm a lot older than you, so I've been around a bit, but this kind of concept of the shadow director or de facto director.
Yeah.
Obviously, given the demographic of our business population, largely family owned, vast majority would be SMEs. 93% of manufacturing businesses have less than 10 employees. 99% of them are less than 250 employees. So, I mean, that's who our community is. So, there's
Mm-hmm.
probably people within those businesses who are essentially operating without having the business card or the sign on their door saying they're a director, but they're operating as a director. So that seems to be something that people need to be not just aware of, but kind of careful in terms of involving those people in decision making processes.
Certainly, if you are a relatively senior employee in a company, if you have a control function, but you're not listed as a director, as you say, family businesses, Northern Ireland, they may have, the shareholder may be the director, but they're not involved in the business and they let somebody else run that. And if it's you're in a business and you are that sort of key decision maker, you're signing contracts because the shareholder director is just not there because it's really just a sort of financial investment for them. You need to be well aware that you'll still get caught because somebody who runs that business for someone will be considered a de facto director. So it's important to sort of know, like, just because you're not a company's house, it doesn't mean you're not captured by the regulations and the duties that you owe to the company and the shareholders and that. We would see the more the shadow director thing is maybe a first generation director shareholder who takes their name away, wants to sort of step aside, but is still making decisions in the background. And ultimately, these things only play out. Most of the time, they only play out when we see them is if insolvency happens and the insolvency service is going after the person who's actually been making the decisions in the background. They've just been keeping themselves out of it, on paper.
Very good. And obviously we touched upon the predominance of family-owned businesses that we have in our manufacturing community and indeed our entire business community. And frequently conflicts of interest may arise there. So where people may think that, for instance, it's a good decision for their family,
Yeah.
rather than necessarily for that business. I mean, any advice in terms of handling those conflicts of interest?
Yeah, I suppose it's always a lot of the time there won't actually be a conflict. We would discuss this with clients a lot. They think, well, I've two interests here, but a lot of the time those interests will be aligned. My advice would be, look, as soon as the alarm bells are ringing, you're flashing, you're thinking, am I considering this from the right angle? It is take advice. If there's articles of association, if there's a shareholders agreement, if you're a shareholder as well, there are approval consent mechanisms, things covered in there that then will sort of alleviate you of any responsibility. But certainly I'd be sort of saying seek advice in the first instance if you're not at all sure.
And helpfully, you've put your contact details at the end of the presentation to seek that advice.
Yeah.
Another couple of questions for you. Obviously, you talked about the kind of, from a legal perspective, a lot of this is kind of in and around the financial stuff, absolutely. But manufacturing businesses in particular are very aware of the role of the health and safety executive, the role of everything that they do needs to be risk assessed, and that risk assessment's updated quite often because sadly people have been badly hurt or even worse, lost their lives, not just in manufacturing businesses, but
Mhm.
others. So so that health and safety piece is just as important as the financial piece. I know you accept that. Uh, but can you kind of define the kind of legal consequences if people don't meet their health and safety obligations, never mind the financial obligations?
Yeah, look, as much as health and safety and HR isn't sort of my area of expertise, it absolutely the the regulations, the penalties around it are sort of huge. I do know, again, and I'll touch in the middle of the slides, that if you're not an expert in health and safety, if you don't have an HR, sorry, an H&S team in the company, it's get external support. If there are risks, they need to be covered off. You need to show that you're doing everything possible. I have seen cases where there's been serious accidents in companies. We've been involved where the, the research, the investigations that are carried out are absolutely meticulous by the executive, and you need to demonstrate every step of the way that everything's ticked and checked, and people on the webinar will know far better than me. You need to have those checks in place. You need to have the paperwork. It's the same with directors' meetings. Everything needs to be carried out meticulously. So again, I'd say if it's something that you don't have the expertise in house, it is to bring the support in and go to an expert.
Yeah, because people can lose their liberty if they don't get this right. I mean, the
That's
laws
the
in and
that's
around
that's the
corporate
absolute doomsday.
manslaughter,
Yeah,
and
absolutely.
so it doesn't come without real hazard for directors, or even shadow directors, or people with responsibility within business unless they get this right. So it's definitely worth paying as much attention to that as it does to the the uh, the,
That's ultimately
the
where it
balance
goes,
sheet.
Stephen. It bypasses, maybe somebody down the food chain in an organization. It ends up with the people who are sat around the table.
And kind of finally, we'll talk about the dirty money, the last the first responsibility for directors and stuff that they all kind of really know intimately well. But obviously, we're in a tricky period as an economy in the UK. It's uncertain what will happen across the Atlantic. There seems to be decisions taken at whims and instantly and then reversed. But it's an incredibly uncertain world as a result of that. And in that uncertainty, businesses do struggle. Let's be honest. Uh, but are there kind of preemptive steps that many businesses who might be struggling financially might need to right size their business in terms of workforce, et cetera, et cetera, et cetera? But are there things that people should be doing in order to preemptively avoid insolvency and to avoid litigation? Because once you get into a court, it's already too late in many respects.
Yeah, I mean, directors sitting around a table will lean heavily on their finance director or in-house accountant at times like that. And I suppose all I can say is, I mean, directors know that when a business, they know if they're on an upward trajectory or a downward trajectory, and if there's that sense of a downward trajectory, it is really that every board meeting we'd be saying, you have your finance head there, your finance director, whoever it is, the management accounts, be looking at those, and you'll know when things become precarious. And if they do, it's at that stage to show it will be a case of demonstrating by paperwork, by minutes, that you have been paying attention to this, that you've taken the steps. I sort of talked, it's steps that you knew to take, or you should reasonably have been known to have taken. So it's really to demonstrate that you're considering this along each step. You've charted the sort of you've charted how the ship's been sailing, and once things do become precarious, it is to approach an either an insolvency lawyer or an insolvency practitioner, just to sort of take advice at that stage, because it does come back again to personal liability. And if you can demonstrate, look, I was taking these steps, I was paying attention to my duties, I knew I had to think of the interests of the creditors at this stage, it's the chart that you have been doing that each step of the way.
Thanks, Glenn. leadership within any business is a very lonely place, particularly if things start to go wrong and people all throughout the business look to the leader because they expect them to have all the answers, and that just adds further pressure. So for a leader, we certainly recommend reaching out, taking good advice, build your own network of people that you trust in order to help navigate whatever difficulties or problems they are. And certainly accountants and lawyers are really important parts of that process in terms of ensuring people take the not just a decision but the right decision as often as they possibly can. So in terms of people getting in contact with Miles Selig or yourself, what's the best route for that?
Listen, the website's there, millselig.com. If anybody wants to chat over anything, drop me an email. It's on the screen, or just give us a telephone call, Stephen. We like to think of ourselves as an approachable firm, so have a chat or sit down with somebody.
And I can confirm it. I've had personal experience of working with you guys in this job, and it is that personal experience is an approachable. Being approachable is really part of the brand. So we would recommend people do that. Just pick up the phone, have a conversation. No one ever lost anything by having a conversation. So it's probably the best place to start. Glenn and Robert in the background as well. Thank you so much for your presentation. That was clean and concise and incredibly helpful, and hopefully it's been useful to the people watching. And we are doing more with Mills Selig over the next couple of weeks, so do look out for the invitations that'll be coming in to your email inbox, and we look forward to seeing you all again. Thanks very much.